Okay, dear guests and colleagues, those who are strong enough and are still here, we could resume our session. And as in previous session, we started to talk about patent system and future of patent system. However bright or promising the future option of unitary patent might be, it is still the future, which is quite uncertain and nobody knows how it will work. Nevertheless, patents exist already. And in all fora, almost always, when we talk about patents with audience, the questions arise: why to patent and what for patents are? How can we get some economic benefits from patents? Because in the end, patents are not an end goal of patenting procedure. Patents are just tools to raise your competitiveness. So therefore, this session and beginning of the tomorrow agenda will be devoted to commercialization of inventions and practical use of patents. Therefore, the best speakers can be the users, the practitioners of the system. And we have a pleasure to host here a wide spectrum of users, from the big representatives of big industry to the SMEs, some of whom we already heard, to the public scientific institutions, to universities. So, therefore, now I would like to introduce our first speaker in this session, and she is Maaike van Velzen. Miss Maaike van Velzen works for big industry company Philips. She is head of IP portfolio unit of a special segment or branch of Philips called Philips Health Tech. And she is experienced patent attorney, and her job includes all aspects of patents, from drafting patent applications, prosecution of applications, counseling, advising how to use them, and litigation also. So, Ms. van Velzen, please, floor is yours.
Thank you. Thank you for the kind introduction. And I would also like to thank the organizers, actually, for inviting me to this conference. It's a pleasure to be here, and I've had a very interesting day, starting with a lot of context and more broader scope views from the policymakers, actually, and going now in more depth with some truly innovative examples of companies that I've enjoyed listening to so far, and I hope you have as well. And therefore, I'm kind of modest actually being here as Philips, because although we have a lot of IP, I see a lot of innovation actually happening outside Philips as well. And what I hope to show you is that we recognize that innovation is done everywhere in the world, and that IP is actually an enabler for cooperation between large companies, small companies, universities, and that we use systems like the European Patent Office to come to really good, strong IP that will help us foster these joint innovations. So what I'll do is I'll give a short introduction to Philips, then talk about our IP portfolio, talk about the role of European patents in that global IP portfolio, and then I'll talk shortly about IP and innovation in general to close the loop, because in the end, as mentioned, it is not about the patents as such and all the IP rights as such, but how you actually enable getting value out of those rights and doing business with them. Philips is a long history company, an innovator company, founded by two brothers a long time ago, over a century ago in Eindhoven. And from a focus company in lighting, actually, Philips transformed into a broader consortium with all kinds of activities in lighting, the medical domain, consumer electronics, and consumer lifestyle products. Today, Royal Philips, headquartered in Amsterdam, actually is composed of three sectors. But I'm sure that many of you have heard about the announcements that we will create two solid companies, one in health tech and one in lighting, out of these three sectors in future. And that's all going to happen in the next 1 or 2 years. We're a global company. We have more than 100,000 employees worldwide and have about 21 billion in turnover and a brand value of about 10 million according to the Interbrand rankings. We have presence in over 100 countries in R&D, and about 7% of the sales is actually invested in R&D to actually create new innovations. And we lived long on a slogan called Sense and Simplicity that you might know. But under the current leadership of Philips, actually we changed our slogan to Philips, Innovation and You. And that is actually to show that we strongly believe that at the heart of growth is actually innovation. That innovation in all kinds of ways, in technical innovation, but also business model innovation, brand innovation, innovation in our processes, that innovation is at the heart of the growth of our business, but also at the heart of growth of economies around us. The Philips IP portfolio is there actually to provide protection for what we do, but certainly also to help us enable opportunities for our businesses. It is really opportunity-driven, the way we actually steer and manage that portfolio. And we never look at one type of IP in isolation. So when looking at these numbers, please realize that they all represent certain inventions, certain trademarks, certain products that are on the market, mostly, and the combination of the patent rights that we have, the designs that we have for our coffee machines and for the toothbrushes and for the medical devices, the domain names we have to enable us to act actually through the digital marketplace, the trademarks we have, all that combination actually is what we use to provide support for our businesses to grow. In addition to those registered rights, we also have what I call a question mark number of trade secrets. Trade secrets are getting more and more important for businesses in a fast-moving technology world to actually secure your know-how and to make sure that you can act against others. And we've heard some discussion on that this morning already, and we very much welcome the strengthening of trade secrets legislation and good ways to enforce trade secrets. Because we also see that the number of events in which trade secrets are harmed actually is unfortunately increasing. So where we've seen many litigations in the past based on patents, I expect that in future we will see more use of the other types of IP, not the least trade secrets, but certainly also in designs and trademarks, that more of those rights will actually be the subject of patent litigation going forward. And not the least because those will actually help us to act fast in the market. We've heard before that for some markets and certain product developments, the patent system could be considered too slow to keep up with the market pace. But that's not the case for every development, I must say. But there are products in which the turnaround time of technology is so high and the new technologies come on the market so quickly that other types of IP like design rights and trademarks or maybe utility models are actually much easier to use and faster to use in acting against competition. So for that reason, we look at our IP portfolio in a global way and in seeing how we can actually help our businesses, and we tune the composition of the portfolio for each of our businesses to the type of market they are active in, the geographic market, but certainly also the type of technology and the role technology plays in innovation, or whether it's more digital innovation in which certain types of IP are more valuable than others. When we generate this portfolio and manage our portfolio, we look into 4 models by which we expect to generate value. And those models are not static in time. Very often we start thinking that a certain technology will give us an exclusive access to the market, that we will be able to protect a certain benefit of the consumer, that we will be the only ones bringing that to market, and that we will feel strongly protected by our IP. But in many occasions, actually, the outside world is working on similar developments in parallel. And maybe exclusivity is not the way to go, but we will be actually looking for For example, cross-licenses with others that also develop a certain position in that field. That's what we refer to as the mitigating model, where we actually balance our own IP position against that of others and use each other's mutual position to come to a cross-license. And this is to the benefit of both parties. Both will actually have lower licensing cost, lower IP risk in the market, and can actually make use of each other's technology. And that's what we advocate very much also in the company for those areas where we have cross-licenses in place, that we actually stimulate our scientists to use technology developed by others, because this will actually bring technology to the market sooner to the benefit of patients and other consumers. And we see then that the use of technologies developed in a broader sense in the market, no matter by whom, actually in general brings innovation to a higher level. So there we see that actually cross-licensing based on patents enables bringing innovation to the market in a broader sense. We also use the licensing model. This is not a model that we would usually use by choice immediately, but there's many innovations actually where Philips is only able to bring part of that innovation to market, or where we actually address only part of the market. For example, we address the consumer market for a certain technology, but there's a large professional market that could be addressed in addition to that. And then we're always willing actually to license to make sure that the full benefit of the technology is made available to the market. There's also occasions, and that's the bottom right model, the defensive model, where we feel that we actually need some IP to be able to defend ourselves in case we're sued. And this happens if we enter a new market with fully new products where we have a limited IP position, certainly not enough to claim exclusivity for our products in the market, but where we actually try to use some IP in case somebody sues us. We say, well, but actually, are you not interested to have a license under this IP? Or maybe we would even counter-sue to make sure that we force, in the end, in the litigation, a settlement. Because we are a strong believer that litigations are actually distracting our business. The main goal of IP, people should not be to have litigation, but actually to reduce the number of litigations as much as possible to enable our business to flourish and not focus on defensive actions, but focus on new developments and innovation in the market. So looking at these models, they will help us actually to identify what kind of IP do we need and how will we use that IP to generate value for our businesses. Well, looking into value, I try to actually indicate a few parameters that at least contribute to value. This is not a limitative list, it is an example list, and the ones that are printed a bit larger I'll discuss in more detail. And it was mentioned before this morning, a strong invention is at the heart of a strong patent or strong IP. So you can't do without that strong invention. That's a condition that's there, and we all need to actually put the bar of what's a strong invention quite high. Next topic is quality patent draft and prosecution, and I'll explain how we actually try to get that to that high quality. Further, the geographic coverage is very important, and the right timing. And then I don't mean being at the patent office as the first party, but actually inventing at the right moment in time and picking the right moment in time to actually capture the value of your IP. And that is not always easy, because sometimes you invent so early, and that happens very often also in universities where such bright people are at work, that they actually spot trends long before it will be really a product that is appreciated and also valued by consumers. So filing too early means that your end of life of protection of 20 years actually approaches much faster than you might have anticipated. So having that right timing actually in filing your IP around predicting when markets will start to emerge, but also when will you actually start using it in products, and when will you build your portfolio for next level protection to extend your protection beyond those 20 years with new patents. That's a crucial thing in a portfolio as well. And then business impact. How do you enlarge the business impact of your patents and your IP portfolio? Looking into quality, and it has been said many times, I think there are several stages at which you can bring in quality. And quality is really key to also the appreciation that people have for the patent system and the use of the patent system. And drafting is the first stage that can help, where actually a solid level of the profession of patent attorneys and those who draft will help actually increase the level of the patents later on. The second step is the search. We would usually carry out an in-house search based on the knowledge of our scientists and a specialized department in IP searching. And then we would actually value very much the search that we do at the European Patent Office in the first priority year, because that gives you a very strong view on the prior art, and it helps you actually also to amend your application or maybe pull back the entire case and save yourself a lot of investment in time and money to continue with something that might not be patentable after all. So we see that as a very valuable thing to do. And as some of the other speakers have indicated, we have great appreciation for the quality of the EPO examiners that help us actually achieve our goal in getting very strong and solid patents that we can use later on in court or in negotiations should that be needed. So that's where actually in the total context of our global IP portfolio, I see a large contribution actually for the European patents that we have. They're used as a selection also what to continue with after the priority year. And the same applies actually for the ongoing PCT process that we use very actively to get an early opinion on patentability and use it to tune our filing schemes and use it as a measure of quality for the filings that we have. Going forward in the prosecution, we as a large company in IPNS, the division I work in, Philips Intellectual Property and Standards, we have offices around the world, and we have people prosecuting the cases in China, in Japan, in the US, and in Europe. And we notice that it's difficult to get one unified view from all those patent offices on the prior art and on the scope of protection available for your invention. So unified prosecution and the trend there is to share files and to use prior art from searching in country X, in country Y, and to enable that and make that more easier through harmonization in the work of the patent offices is of great value for us, because that really ensures us that there is a general way of looking at the patent and that we have not a real risk of fragmentation in scope. Because what has happened to us often in the past, and those of you who know the coffee machine Senseo might be well aware of that, is that we ended up with patents of different scope in different countries and decisions of infringement in different countries that were pro-Philips on the one hand and negative for Philips on the other. And that created a lot of lack of harmonization, fragmentation in the business, and also a difficulty to really set our strategy. So the approach that we see happening now with unified patents, the unitary patents coming into force, one way of enforcement is actually one that we would promote and we would be very much open to and supportive of. And that means that in enforcement, we expect, based on also what I have seen in many of the blogs on the internet and opinions from other companies, that there is a good chance actually that litigation fora will change in terms of geography from a huge emphasis in the US at the moment to more litigation in Europe if that becomes so centralized and affordable. So I think that's something that we need to be ready for as companies and also as anyone who files for IP, that the US will still remain very important, of course, because it's a large market. But if litigation becomes so centralized and relatively easy and a smooth process, that Europe will be a far more attractive forum as well. Looking into geographic coverage, important to have a portfolio that actually covers the long-term vision that you have on market development and the life cycle of technology and competitive environment. And we as Philips, we regularly try to acquire IP, or we acquire companies that are small and medium enterprises as well. And one thing that we often regret in that is that the IP protection that companies have asked for is of a relatively limited geographic scope. And that can also be understood because the market that a small company envisions is not always immediately global. But if you want to make yourself ready actually for being attractive for an acquisition, then a broader filing scheme covering main markets across the world is actually very helpful. One of the things that has helped us actually is the market coverage by European patent, which continues to increase. And the extension possibility to Morocco that came into force is actually very much welcomed by us. And also the further discussions that are being held with other countries will actually make it easier to have one patent of one scope in many countries, one centralized prosecution process, increasing your market coverage and helping you actually to make the right decisions at the right time. Because the earlier you need to make the decision also on country coverage, which is the case nowadays, that you really need to pick the countries where you want to have your protection. It's difficult to predict how economies will develop, how the GDP of a country will develop, how products will do in a certain market. So the unitary approach actually helps us to make those decisions easier and will help us also to get protection in those countries where the markets really take off. Well, I mentioned already litigation could increase in Europe as a result of all the recent developments, and I think that would actually be something that we would make ourselves ready for by continuing to invest heavily in our European patent position. Business impact also contributes to value, and that means that you need to look into how can I actually generate value with my IP. And typically the types of IP that generate value, the patents that really make it in the end, are those covering products in your market and alternatives there too. Generally we try to have protection for our own products, but also for a shell of activities around that, because those who actually want to mimic what we do are very inventive and try to actually stay close, but are not always exactly the same. In addition, we try to build IP around the competitor's roadmap. That helps you to be in a favorable negotiation position if you want to do cross-licensing, for example. And we try to anticipate on the general future trends. And that means actually that as people working in IP, it's not only about drafting and prosecution, but it's also thinking about what will be the future trends in the market and in technology. And that's where you should actually invest in building your IP portfolio. And then really having coverage for basic technologies always helps. Having said that, I do realize that many of the basic technology patents that we have actually have a very limited lifetime of use for return on investment. Because very often basic technologies require a long time to really get to market. And only the last 5 years or so of the patent life, the market is really taking off and you get your revenues in return. That depends a bit on the area, so it's a bit different between health tech and lighting and consumer products, but generally the later years are the more valuable ones. Looking at all that IP and the portfolio we built in that way, in Philips we are really convinced that IP is there to help drive innovation. The key to economic growth is of course the business activities themselves, but the opportunity you get that when you use actually IP as an asset, when you dynamically use your IP and try to use the full scope of it by not only using it for your own products, but also looking for the licensing opportunities to address larger markets, is really huge. And hence you can use IP actually offensive as a tool in business deals and supporting growth. IP can actually enable joint development by putting the right conditions in place on ownership, who owns what. And once you've agreed on that, it's much easier to talk to each other and to be open in a technical cooperation. It also enables partnerships and strategic longer-term partnerships. And Senseo, the coffee machine, is one example where we really developed with a partner a product till the end of lifetime to market. And in that deal, we also paid attention to how will we actually share revenues? How will we do that together, actually, longer term? And IP was the foundation based on which all those arrangements were made. And IP is also an enabler for startups to take the next step. As a small company, if you are in a technology-intense domain where IP really plays a role, then having your IP position as one of your attention points means that you are one step ahead of your competitor who might not have worked on that. IP is an enabler for SME growth. I strongly believe also that companies that actually want to grow have two options. You develop your IP yourself, but you can also look around you and look at universities, look at other parties' IP, look at Philips IP to see what could you use from that actually to build a business. And many of those companies and IP owners will be open for a discussion on licensing or helping you actually start your own business. And that is something that I see happening more and more in future. And then last but not least, it's an enabler for cash income. And if you do that cleverly, you can use that income actually from licensing to invest in your core business and innovation in that core business again. The last bullet I've put the defensiveness to really protect your position in the market. that use of IP is one that was traditionally very large, but I see the developments going, that IP is much more used offensively rather than as a defensive tool in the market. And I think that's to the benefit of economic growth and the public. Well, I hope with this I've given you some flavor of how we look at IP, how we build the portfolio in Philips, what we see as important parameters to create a valuable IP portfolio, how we very much appreciate the developments that are ongoing currently with the patent offices on harmonization, more options to cover multiple countries with one patent, and multilateral cooperation over various countries, because that really helps us build our portfolio. And I hope that I have also invited you to actually take a look at our portfolio and see whether there's anything that you think you could build a business on, because the entrepreneurship is actually at the core of generating value. So if there's any patent that we might not use to the optimum, you feel you could do better, this is your invitation. Thank you.
Many thanks to Ms. van Velzen. So we had a view of how to use strategy and how to use intellectual property in a big company. Now we will turn to quite different user of patent system, namely to public scientific research institution. The next speaker will be Professor Ivars Kalviņš. He is director of the Latvian Institute of Organic Synthesis. He is distinguished scientist and inventor in Latvia. He is inventor or co-inventor for more than 250 patents, and among his most successful inventions are medicines like mildronate, new generation of mildronate, mildronate GX, immunostimulator leocadine, and new drug candidates like belinostat and Nermexan. So, Professor Kalviņš, the floor is yours.
Thanks a lot for kind introduction. I really do not know how to go ahead on Latvian or on English because my terrible Baltic English, but I think probably these problems what we really have in Latvia are not very well known by our colleagues in Europe, and therefore I probably will try to explain all these things on English. So I would speak not so much about the patent system and patent protection as it is, but about that what we can do with our inventions and help. Does this system help us to invent and to protect our inventions, to innovate or not? Because really the society is thinking that scientists should use the money to produce the knowledge. But in the reality, they ask us to transform this knowledge into the money. That means to innovate. And if you would like to do it, then you have to stress the politicians to create such a regulation which is predictable, flexible, simple, and effective. Unfortunately, we are far away from that. I would say in different countries there are different types of ownership system, and you know that there is countries where we have this professor's privilege when this invention, what was made even by using of public money, the ownership of this is belonging to the professor who is the inventor. And the other is the institutional ownership, which is very popular in many, many countries. But the crazy thing was that some years ago, Latvia was the single country in the world where every kind of ownership of IP was belonging solely to state. what happens then, you can understand what is going on. I will not concentrate on these preemptions and other types of rights, but I would say Latvia and all other small countries need professors' privilege system. Because many countries who has a large industry or large economy, they can allow them to use this institutional, but not such countries like Latvia. What the advantages of that system is, because really what to do with the invention knows better the inventor, not the institution. And in Latvia were created 8 technology transfer points at the universities, and there are some people working and they have to cover whole field of all sciences, and to do this on the best efficient way is nonsense. Nothing is coming out from such a system. For sure, if we are speaking about large companies who have their own research centers and many, many scientists working, this is completely different thing. But if you have in the, for example, IT area or branch in Latvia, probably 15, probably 20 real powerful scientists, then what? You can ask somebody to write the right patent for the invention what they made. Who told about the Jānis Ošlē told about that the child should be burned by yourselves, not by somebody else. So, there you have already read it, I think, about, we have 2 regulations. One is included in the law of non-scientific activity, which regulates how the public institutions should go ahead with the IP rights. And the other one is the law of which is regulating patent application and rights as whole. Yeah? But where is this main problem? Really, the inventors in public institutions are not interested to patent their inventions. So, what's going on? Okay. So, why? Because if the rights to use this invention belongs to the institution, then you can forget your invention. It will nothing come out, and I will demonstrate you later why. So, but the next issue is remuneration. If you are not expecting any remuneration for your invention, you will be not actively transforming your idea to real product. But in the private sector, there probably the situation is much easier, because you know what you are doing there. Really, you have some obligations against the employer, and okay, the employer and you make an agreement, and you know what you will get at the end. Yeah? This is not the case in public sector, because you are asked to produce knowledge, not inventions. And then is the problem why you should invent. Why? So, for any IP protection, first of all, you need funding. In Latvia, for public sector, there is absence of any funding for IP protection, maintenance of patents, etc. As the result, IP protection in the public sector does not happen, and innovative ideas are published and lost, therefore. So then our recommendation would be that the national support program for funding of to support inventors in public sector should be created. In opposite case, nobody will be able, first of all, to maintain the patents. And there is another problem. I understand large companies, they are very glad about that the unitary of the patents and patent cards, etc. From my point of view is perfect. Less job to do. But the praxis is sometimes quite opposite. Because if you have this national phase and you got some expert in this unitary system which do not understand really your topic, as Ursula told already, then you have lost your invention. There's no doubts. But if you have a national system additional to that, then I have many times this example. I got a patent in the United States without any objections. In Europe, no, this is so, and years and years and years, at the end, you got the patent. But why I should repeatedly convince somebody about what is, from my point of view, of scientist's view, this is obvious. No problem. This is new and inventive, etc. Yeah? So I would say a good example is Estonia from my point of view, where the scientific institutions has a right to decide on the use of results of its activities. In Latvia, we have 3 pages of law written how I should go ahead, how I can protect, and how I can remunerate, and in which case what. But the problem is that in our law, for example, to the scientific institutions belongs only the inventions if they are 100% funded by state budget. But we very, very rare have such a situation. We have different sources for this project. For example, European money, our own money, some of industrial partners, etc. What to do then? How to divide, how to distribute the profit, etc. Yeah? So the recommendation, as I told, the institutions should be able to use all the IP for different purposes. To invest in some new enterprises, whatever. But now this is so strictly regulated, then forget it. Nobody will go ahead if there will be different regulations for different mixtures of different sources, etc. So, what is the conclusion or the result? Latvia is the modest innovator, and you can see that, okay, some improvement in innovatory capacity is have been observed, but nevertheless, we are still among these 3 last, these modest. And this is policy. First of all, the policy. You can see how the innovation performance of Latvia was growing and then dropping down. What does it mean? It means that in years starting from 2008 till 2012, there was in power this crazy law. And the public sector discontinued to invent at all. And now you'll see what happens there. Yeah? And the reason for low innovative performance of Latvia is First of all, we are the small economy. That means we have rare, large enterprises, and these large enterprises indeed are monopolists on the market of Latvia, and they don't have their own research centers at all and don't need any invention from the public sector. And if we are looking for small and medium enterprises, in Latvia, it will not work. This invention based on SMEs can't be a real power because there are only 16% of all scientists in private sector. Who will invent if there are there is so small amount of scientists, only 570 people altogether in all sectors? This is nothing. So, and from our point of view, it is not true that we are not inventive. We can innovate, we can invent, etc. But then there is lack of infrastructure for innovative research in public sector. Nothing left. We are obliged not to use the scientific equipment to make innovations. It is restricted by law. So, next, absence of public funding for IP protection in public sector. In commercial sector, you can get the money for patent protection, but not in public sector. So, and the policy, if the government is asking us to be evaluated, and evaluation is based on scientific publications, then who will go for patenting? First of all, timing, second, money, and third, uncertainty that you never know what really will be. You start to protect your invention, but you will really know, or you will see what was invented after 18 months. And if you have no patent funding, you have to find really immediately somebody from commercial sector to whom you can offer your idea. You really don't know, is it patent able, because this is 18 months to wait for it, and you have to enter national phase after 12 months. So, this, therefore, the IP protection does not happen in public sector so much as it can be. So, and next issue was, I have learned that there is some improvement. If it will be this regional patent office, then it's okay, but still till now, we very rare applied as the first application the patent in Latvia, because we want to see this investigator's report about the patentability of your invention. If it is not possible, in Latvia it was not possible, then we try to apply abroad first. And there are some other things, stupid, crazy, I don't know. For example, based on bilateral agreement, Latvia recognizes USA patents as valid in Latvia, even these has been discontinued in EU. Why? Simply so, gift for USA. That's it. Then, okay, you can apply for court and ask to discontinue the patent, but our courts are working so slowly that you can forget, never will see the end. This is so. And how much Latvia is really patenting? You see here some figures about the US patents for country, and Latvia, that is written 8 patents in 2010 per million inhabitants. I will demonstrate this is not truth. Okay, this probably performance of innovation in Latvia is not so high as it can be, because if the public sector would be supported in this process, the results would be completely different. Or the opposite one, if the commercial sector will create their own research. But for that, they need the people there. And look, this was official statistics. Latvia is there behind Nigeria, Zimbabwe, etc., Bermuda. So, yeah, very, very impressive figure, yeah? But in the reality, the Latvian Institute of Organic Synthesis, in collaboration with our customers, applied and became granted in this year, 2010, only 13 patents of USA. If you are looking for whole Poland, there is 56. But indeed, at that same year, we got 53 patents, different. And then you say there is only 8 patents for Latvia. Why it happens? Because we don't have the money for application. We need the customer. We sell our rights out, and they apply as it would be an invention from the United Kingdom, the United States, or whatever. And now some unresolved issues of patenting from my, as inventor, view. One case I would explain. This is about how to construct new bacteria, new viruses, but not by methods of engineering, gene engineering, but simply by applying some mutagens and selecting the result. The problem is how to protect it. You get the virus, or you get the bacteria with very usable properties, but how to protect it, because you will never get the same virus or bacteria if you apply the same approach, what you used, really, because mutations are unpredictable where they will happen. Next case is enantiomeric purity of the drug. You know that in the case, if you have racemic mixture from let's say two hands, yeah, and only one hand you really need for achieving the pharmaceutical power of this medicine, what you can do, you should purify the compound and get only one enantiomer. Okay, this methodology is very well known. Nothing inventive. But the result is very useful, because you apply as medicine a compound which is 100% purity, not 50, as in a mixture. If you will not be allowed to get the patent, no one company will produce this product which is needed from the patient side. Next is the Marcus rule. There were in past and also now so many claims generated about non-existing compounds, non-existing results, etc. First of all, you can't find it. This is really a hard job to do. I have always this problem to look for this. And at the very end, you lose millions of new compounds with useful properties, what could be the new medicines. But it will never be medicines, because they are under Marcus rule, they're hidden. So I think should be discontinued, this approach. Once more, now we know about the genome of humans, and we know that there are at least 30,000 drug targets. Against them you can construct new medicines. What the companies are doing, They are isolating these proteins and patenting them, protecting against search and use this for creation of new medicines. What does it mean? We would like, okay, it will be the case, all 30,000 of receptors will be patented and stop, nothing more. So this was really only some examples about what I would say about this system. For sure, I'm a fan of the unitary system, but we have to think about the quality of examination, because in some cases, for example, one of this WIPO, evaluation of one of my patent, I have written this is genetically stable RNA virus. Oh, nothing. Then I asked the examiner, did you see any stable RNA virus? No novelty. How no novelty? You have stable. But they don't understand this. And this is the quality of the examiner there. Okay, if it will be highest level, no problem. But if there will be lower quality, then we will lose against United States, because it is much easier to get a patent in United States as in Europe. Thanks a lot.
Thank you, Professor Kalviņš, for your passionate speech. And now our last speaker for this session. Maybe we will hear different experience, because our next speaker is also from, as I understand, publicly funded university, namely Dr. Alexandros Papaderos. He is a deputy head of Office for Research and Innovation, head of patents and licenses at the Munich Technical University. Mr. Papaderos is frequent speaker on technology transfer and commercializing results of scientific research. And please, Mr. Papaderos, the floor is yours.
Thank you very much, Ms. Rozenblate. Congratulations, you made it. This is the last presentation. You were all very brave. Thank you very much for staying here. And thank you for the introduction. And of course, for the invitation to talk to this conference in the lovely city of Riga. I have not very often had such a nice view while talking. I mean, besides you, of course. The conference, it's called Intellectual Property and Beyond, and I'm going to talk about the beyond, I hope, more about the beyond. Why a university should deal with IP and how a university deals with IP. We are a so-called IP-intensive industry. We produce IP. We don't have any other products. And of course, we use the IP system and especially the patent system. Yes, I hope I will give you some different insight in our work, but some things have already been told, and no session is finished before everything is said already, but not by everyone. So, the Technical University of Munich. We have 13 faculties. Amongst them, about 11 are what we call IP relevant. We have about 9,000 potential inventors. 1/3 of them are our scientific staff, but we have also inventors from our non-scientific staff, and of course students who invent and have ideas. We have a budget of something more than 1 billion euros. We close about 1,000 research agreements with industry every year, not counting the service agreements that we have. On average, about 170 invention disclosures per year. last year we had almost 40 patents filed. It wasn't really a good year, but you can really have high numbers of patents every year. And at the moment we hold about 200, 220 patent families. This is our the environment where we work. We have a very strong research network with 3 universities around Munich, and we have also a lot of non-university research centers with which we have collaborations. On the other hand, we have a very strong industry network, being a technical university. And this morning we heard by Ms. Jonna that BMW is using robots for assembling cars. So be assured that in every BMW in this world there is a little TUM, a little Technical University of Munich inside. And of course other renowned partners with which we have long-term collaborations. And for both, for research and for industry partners in the collaborations, the IP plays, of course, a very important role. And we do this not because it's fun, as the colleague this afternoon said, but also because it's, let's call it a duty from the Bavarian higher education law, where we have to work together with industry in order to promote knowledge and technology transfer. And of course, in our mission statement, we commit to the innovative progresses in the fields of science that promise sustainable improvement in how people and society live. Almost 10 years ago, we published an intellectual property policy where we see the commercialization of research results as a part of our mission, and especially the formation of business entities, spin-offs and startups by using the university's intellectual property. So how we do technology transfer? Technology transfer it's a business, a very people-intensive business. And first of all, we do the knowledge transfer when our staff is going to conferences, when it makes presentations about their newest research results, or when bachelor and master theses are made within our industry partners, and when our staff is offering consultancy services. We get to know the latest trends of research and industry. We, of course, have contacts. Our graduates find easier a job at industry, and, of course, we exchange experiences. A more classical way to do technology transfer is by collaborating, for example, with industry partners. Classical way to have a contract research or cooperate at the same level, and long-term strategic alliances where we build creations of centers for scientific excellence, establish long-term relationships, and have the chance to access to external expertise and equipment for a long time. And the reason why we are here is the technology transfer by intellectual property rights. We commercialize the protected research results, and we try to use the startup environment to give the IPR to new companies from the university. And one reason is, of course, the financial outcome of these activities, but not the most important reason. For me, the most important reason is for having reputation and to prove your competence by having a certain number of patents. Very simplified, the life cycle of an invention in academia. First of all, you have to create an infrastructure at the university. An infrastructure means you have to have the right people, you have to have the budget, and of course you have to have the policy from university management that IP and technology transfer in general is very important to the whole university. This will create also what we call a patent culture inside the university, and the reason of all these activities is to raise the awareness for patenting among the scientists. I remember the first time that I heard about patents was in the middle of the 90s when I met a friend of mine who was a patent examiner at the APO. He was in Den Haag and wanted to move to Munich. And so we had contact, and he was the first person to explain to me the patent system. And it was in the middle of my doctoral thesis. Before that, I really haven't heard anything substantial about patents inside the university. So when we do our homework by raising the awareness for the patent system, then we receive reports of inventions from our staff, which we have to evaluate. I would say a few things about that later on. We use external expertise for evaluating inventions. We, as I said, we have 13 faculties. We don't really have the whole expertise in-house, so we have to use external people. And there is a decision of releasing an invention back to the inventor or claiming the rights and patenting. For the patenting, we again use external expertise, patent attorneys. And the reason for patenting is actually commercialize. We don't have a hall of fame at my university where we hang all the patents, so we try to commercialize. And the outcome of the commercialization is the revenue sharing between the inventor, the institute where the invention came from, and a part which stays at the university in order to keep this cycle running. And Germany has a lot of laws, and it has also an employees inventors law and a special clause for university inventors. And according to this law, the inventor receives 30% of the gross revenues. So it's written in the laws. We don't have to negotiate anything. From every euro we get, the inventor receives 30 cents. Let's talk a little bit about patenting strategy in academia first. So, as I said before, at least what our university concerns, reasons for patenting is for commercialization. And let's say about 5% of the decisions we take are of strategic nature. For example, if we see there is a certain technology which the time hasn't come yet for commercialization, therefore we already invest in patenting and protecting it. Of course, when you want to patent an invention, it's about its economical potential. Will the user of the patent will have an economical benefit from it? And now, for academia, it's very difficult to explain this to scientists because the scientist thinks he has made excellent science, which is often the case. And he, of course, invented a lot of time and a lot of budget from the university. But it's like when we decide not to patent because we don't see the marketing potential, it's like when you say to a mother, your baby is ugly. So it's a very difficult thing, and of course, also what's very difficult is to find out the economic value of the invention. That's why we have all crystal balls in our offices and look inside to see the future of the patent. And anyway, the decision to release a patent to the inventor is based on the fact that or on the estimation that we won't get not even the patenting costs back in short time. And as you said, Ms. Velzen, especially for university inventions, it's more difficult to make a prognosis because they're very premature. The other problem that we have is that we get a phone call today. Today is Tuesday. The inventor wants to fly to US on Monday to make a presentation, and he thinks that his idea is patentable or has a market value. So we are rotating and try to find a patent attorney to file a provision application, which of course causes a lot of other problems. Now, Ms. van Velzen has already said a few things about patent strategy in business, so it's very short. Of course, it's about protection, about the ownership of the ideas. It's about licensing or cross-licensing. It's about mergers and acquisitions, about patent portfolio transfer, future developments, or blocking or litigating. This is the ugly phase of the patent system. And same at the university, it's about reputation and proof of competence. Going to the patenting strategy, we ask ourselves when we get an invention, so what kind of IP do we have in this specific scientific area? What kind of IP has already came out of this institute? According to the invention, what kind of IP we are going to need? And very often also the questions, do we really need a patent? Should we patent? If this if this question is answered by a yes, then the question is how to obtain this patent, and how this new patent will fit in the business of the licensee, for example, and how the licensee is going to use this patent. Is this patent, will the patentee will able to defend or enforce this patent or this product? We don't defend or enforce patents. We give this opportunity to the licensee because he's on the market. The university isn't on the market. And what alternatives do we have besides patenting? And the question again. Costs and benefits. Patents need a certain market penetration in order to bring financial benefits. In our point of view, the commercialization benefits should at least cover the invested costs for research and development, for the protection, for marketing and production. The question of the key markets for manufacturing and sale, but also where copies might be produced. If we already have a licensee, which is a really best case, we discuss with a licensee the patent strategy. And what we also do together with the licensee is the continuous evaluation of the patent, and therefore working together with the licensee, we try to be as realistic as possible. And of course, sometimes we have to take hard decisions, which are not always liked by the scientists. We have to drop patent applications because they produce costs. And another thing that we have to very often to discuss with our scientists is that patents are not scientific publications. We don't collect patents. Now again, Ms. van Velzen has already talked about this. Now this is another way to put the question of when is the right time to patent. I hope you can read everything. This slide is divided in two messages, but they have to be seen together. So the upper part is the development of a technology from the research to being a success as a business. And there you can see the different stages like research, development, the technology transfer to the product launch, the successes of a new product, what we call commercialization, and then the success as a business. And you see also this very nice curve, and the deep middle of this curve is a so-called valley of death. So when you look at the lower part of the slide, you see very simplified timeline of a patent. We have the first application, then we have the search report, the search request, the search report, the international patent application after 12 months, the publication after 18 months, and then the national validation after 2.5 years. And at the very end, the costs could accumulate up to 50,000 euros. when you are using, when you are validating the most important markets. Now, these timelines are they don't have the same time. The development from research to business success could take years. The lower timeline are the 2.5 years from the first patent application. The message of this slide, and this is what we are trying to tell to the scientists, is that the development of a product to a success as a business has to be synchronized with a patenting strategy. Because at the moment you file the first patent, the time is working against you. The clock is ticking, the time clock is ticking, and the cost clock is ticking. And this is also a very difficult thing at academia, because I told you the story about the scientist who is going Monday to a conference in the US, so we have to patent because he has to publish. Anyway, we try to solve these problems, of course, in dialogue with the scientists, and the majority of them have an understanding, and together with the patent attorney, we either do the filing, which I really don't like in a case like that, where there is no licensee inside, or we convince the scientist not to tell too much about his science, to be a little bit cryptic. In best case, we have time to evaluate the IP, and what we do by evaluating the invention. We try to get some data with the purpose of rating the invention. This means we want to determine its importance. And the data that we collect have legal aspects, for example, like legal status of the patent or of the invention. Also, we collect data about the technology level of the innovation, data about the market, and also information about the inventor or the patent owner. Ownership was also was touched by Professor Kalviņš. It's one of the most important issues that have to be solved before you start patenting. Then again, the options that you have for protecting the intellectual property. Very important for academia, the commitment of the inventors. We often don't patent inventions when we know the inventor will be gone in half a year, will go to another university. So there will be no one there to explain to the licensee about the technology, or to work together with a patent attorney in drafting the patent application. Again, the maturity of the development of the technology and the size of the potential market, the economic benefits, the commercialization feasibility, and the potential returns. So then, if we have a positive evaluation of the invention and we file the patent, then we start commercializing, and then we want to evaluate the invention, which should be anyway a part of a good management also of any company. Anyone should know the economic value and the importance of the intellectual property that he has created. And this information helps you to take strategic decisions, and also can facilitate the commercialization and the transactions of the IP. And knowing the value of your IP, you can also use it for business situations like mergers and acquisitions, like raising funds for venture capital, which is very important for university startups. Of course, for licensing or assigning the IP, support in court proceedings or arbitration, and also support in internal decision making. So then, by having evaluated the IP, we are going to commercialize it, and the most common way to commercialize university IP is by giving licenses to companies. The IP remains at the university, but sometimes we are forced to sell the IP and assign the rights to the companies. It's something that we don't actually like to do. And one method to commercialize IP on which we focus the last 10 years is to provide the IP to university spin-offs or startup companies in form of exclusive licensing, of selling and signing the IPR, and obtaining equity in this university startup. By licensing the IP at the university, there are some things to be considered, like the technology and its uniqueness, of course the stage of the development, the position of the technology in life cycle, is there competition, what are the technical, financial and marketing strengths of the licensee and of course of the university. How strong is the IP that we're going to license? Does the licensee have a freedom to operate, to practice the technology? How much compensation are we going to receive from the licensee? And of course, how much is going to get to the inventors, and how we're going to remunerate them? Coming from a university, we have a lot of factors which are hindering commercialization. A lot of technologies that we produce are not mature enough, are not interesting for companies, and there is very often a gap between what we supply as a university and what the university demand. We have a lot of what I call clueless and reluctant researchers, which are on the other hand, clueless because they are they are scientists. On the other hand, they're reluctant because they don't learn from their mistakes. Some of them have unreasonable expectation about the value of their IP, and in that case, sometimes they underestimate the future R&D efforts that the licensee has to make, and also they underestimate the market risk that the licensee has to take. Many universities have bureaucratic and complex transfer mechanisms, and also inexperienced staff at technology transfer offices, which of course hinders the commercialization of the inventions. So what we've learned the last 15 years at my university is that the so-called third mission, the technology transfer next to research and education, has to be integrated into established structures and process of university, and as a part of technology transfer, of course, the technology transfer to the patent system. We need to have rules and regulations on intellectual property rights and on employment regulations. To give you an example, when we have students working on projects, sometimes there is problems in acquiring their intellectual property. We teach our researchers always to involve us as a technology transfer unit, and we also tell our researchers not to work without contracts with very enthusiastic academic persons who are really don't look upon things like contracts, and we ask them to make contract negotiations their priority, or to leave the contract negotiations to us. What also it could be a problem is the so-called background and sideground IP, which is very important for the implementation of the technology by the industry partner. And saying that is, of course, the problem of aligning the different cultures of industry and academia and the perception of intellectual property. And for example, we always advise our researchers to document any research progress that they made in their projects with industry, and don't only rely on personal relationships, but always use the legal systems in order to avoid misunderstandings. And with these experiences, I would like to close my talk and thank you for the invitation. It's been a pleasure being here at this conference. Thank you very much.
Thank you, Mr. Papaderos. So, are there any questions to our speakers? If okay, we.
I have not a question. I only want to say it is a very after the war, the wife is now better, all better. It is, you have very explained the problems, but I mind the best way is to learn from your own mistakes. And that is a more important thing, to learn from mistakes.
There was another person who asked.
Thank you. I would like to say thank you for all presenters. It was very interesting session all afternoon. And for me, very interesting was point of view from Mr. Papaderos. Sorry if I don't Papaderos, sorry. Especially lesson learned and whole presentation, but I would like to raise question to Ms. Velzen. What is the main reason why Philips changed its slogan? Because I, as a consumer, many years, I like your slogan simplicity. And what is the main reason? Just to refresh or with something new introduce, if it's not trade secret of your company?
No, thank you. No, it's not a trade secret. Slogans come and go, actually, and the time that you use them is there to actually emphasize a certain aspect. That doesn't mean that the previous character of the products announced by Sense and Simplicity is no longer there. It's still one of the foundation values that we have to make products at least simple for use. But the fact that we actually moved to be a company with a different focus, that we have actually divested some of our activities in the consumer electronics domain, meant that we were actually rethinking our values and our brand identity. And around that, what came up over and over again is actually what is at the core of what Philips values is actually innovation. And the decision was then taken to let that come back in our slogan so strongly, because we really value that very much. The new slogan is innovation, Philips, innovation, and you. Yeah.
So, any more questions? More questions? Yes, there are.
Hello. I'm patent attorney. This is an important remark. Today we heard at least 2 times a famous thesis of Dr. Lapsa that it is better to give birth to your child yourself, Mr. Lapsa being the inventor. Just a small comment. As a patent attorney, I cannot leave this without comments. Yes, for sure, it is better to give birth to your child yourself, but it's very dangerous to give birth to your child by your own without accoucheur. So it's necessary to have a good specialist which can help draft your patent, because to get patent is just half of the necessary steps. It's necessary to be able to enforce and defend your patent in counterclaim. So it's very important that professional accoucheur could consider this and draft it as necessary. Thank you very much.
Thank you. My name is Ivars Rozenblate. I am from University of Latvia. I have a question to Aleksandrs. You told that inventor is entitled to 30% share in remuneration. So my question is, how big is inventor's role in decision making? When to patent, to whom assign? Thank you.
No, I'm not a lawyer, but I will answer as a lawyer. It depends. We have all kinds of inventors. We have inventors who are very experienced. We have inventors who think are experienced, and inventors who are not experienced. So we have to deal with every one of them, and sometimes it's easy to deal with them. Sometimes it's very hard to deal with them. It's a personality thing. Sometimes it's an age thing or a status thing. So we welcome every positive contribution concerning patenting and commercialization, but we are not. How can I say? We're not willing to do everything that the inventor wants, because at the moment that we acquire the property from the inventor, according to the German laws, the invention belongs to the university, but we cannot actually commercialize it without the inventor. So we need the inventor as a friend, but not as a decision maker.
May I add some comment to this? The best way is to invite the inventor to participate, to hear, not to participate as the actor, but to hear the process of negotiations, or what the company is asking, what they are saying about the value of this invention, etc. Then they understand better. In the case if the officer from the university will tell you this is probably 1 million the value of this invention, we will sell for 1 million, that's it. This is one case, but if you will, you would participate at the negotiation, and the company says, "I will never pay more than 1 million," then you will be sure that in this case, probably 2 million would be too much.
So, can we conclude for today? Okay, let me thank again our speakers and present you some small pieces of Latvian cultural heritage in order to tempt you to return.
Thank
you. Okay, now the formal part of today's agenda is over, but as you probably know, our agenda is not yet over. We have informal part, which will take place in 1 hour in the Railway Museum, which is a building next to this building on the left side, when you exit this building on the left. And please don't forget your badges and invitations, which are in your bags. And so, thank you very much, and see you within 1 hour in the Railway Museum. Thank you.